Coming up on second session, Judge Simpson reviews the progress made on a defendant's competency restoration. Judge Aquilina oversees a probation violation sentencing. Judge Thornton hears a change of plea, and Judge Oakley holds a preliminary exam on a fourth-degree felony. I've got 4 good hearings lined up for you today, so let's head into court. Good day, everybody. Welcome to second session. Good to have you all here. Let's jump right in. This is Judge Simpson.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Assistant Public Defender, Secretary, I can really, on behalf of Mr. Dion Baldwin, that's who we called, right, Judge? Yes, Dion Baldwin, on Zoom. Mr. Baldwin,
hey, Judge.
How you doing, Mr. Baldwin?
Good.
All right.
Judge, we're here for a competency review. I don't have my notes, but the last time we were here, he was found incompetent but restorable within the time frame. We received a letter from Forensic Center just basically stating that they are waiting for a bed. I have not received any new updates from, I think that was June. Was that June?
I see. It looks like we got a letter dated July 29th, 2026, indicates the defendant is still incompetent and likely to attain competence.
July 29th?
I don't have that.
I don't have that either. So that letter indicates that he is still incompetent.
And likely to attain competence in the statutory.
Okay, then based upon that, and I'll receive a copy of that, I'll set this for a review. Competency review, November 5th, 2026, 9 a.m. Bond continued.
Can we discuss bond?
Sure.
I was requesting $5,000 surety.
Receiving treatment.
Anybody with a P number want to speak up?
No, I was just like, yes. I did.
Tons of them out here from anybody.
That's right.
Go ahead.
Sorry about that, Judge. I did have an opportunity to meet with Mr. Baldwin. He gave me some information that he wanted us to address with bond, but I guess what I was confused about was whether or not he was actually receiving treatment now while in the jail towards regaining his competency. Obviously, the letter that Mr. Cook read to believe that that is the case. Mr. Baldwin says, and I can tell he's been doing much better. I've been working with him for a few months now, Judge, and the clarity that he has, linear conversations, there's a lot that has changed from when we first met. He says that he feels a lot happier. He has been able to regain connections with his family. They have been supporting him while in the jail with commissary and other things of that nature. He was ready to start discussing the case in a realistic manner and was ready to start putting forth a plan. I did tell him that I would hold off on putting a plan together in regards to the case until we can get confirmation that he is competent. He states that he has some funds available to him that he would like to use to assist with.
All that was a long, wind up to the bond argument. Yeah, go ahead.
Fund that he would be able to use towards his housing. He understands what the issue that brought him into jail is. He knows the no contacts and the no go-tos. He assures us that he would be able to abide by whatever bond conditions the court places on him. So we're asking, Your Honor, if the court could consider allowing him to continue receiving his treatment from out of the jail, if that is possible.
Well, would he be? There any response?
I would have concerns about the defendant's ability to remain compliant with law and bond and continue his treatment. If he's still incompetent to understand the proceedings, I don't know if he'd be able to understand the bond conditions when custody and still incompetent. So I would ask that bond will be the same until he is able to be restored to competency and we can have trust that he will abide by the conditions set by the court.
Okay, here's what I'm gonna do, because I'm not sure I heard everything. Not sure I have a full picture of what his treatment regimen. So it's almost impossible for me to assess whether or not he could potentially manage that outside of the facility. So what I'm gonna do, and so Mr. Baldwin, just listen to me. I'm gonna
Yes.
deny the request to change your bond at this time. Counsel, if you deem it appropriate, file a motion with all of that information, and then I will look at it again. Okay?
We do that, Judge.
Got that, Mr. Baldwin?
Thanks.
Thank you. Take care.
Yes.
Thank you so much, Judge.
Really?
Alrighty, friends. Quick one from Judge Simpson to get our day started. The next place we're going to go is Judge Aquilina. She has a probation violation sentencing, so let's check in with that.
All right. This is docket 24-4194-FH. People of the State of Michigan versus Jeriann K. Counsel, your appearances for the record, please.
Good morning, Your Honor. APA Barbucks, and on behalf of the people of the state of Michigan, here with probation.
Good morning, Your Honor. Agent Jessica Farr, Ingham County Probation Department of Corrections.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Jerry Keene, who stands to my right.
Good morning. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth on penalty of perjury?
Yes, sir.
Thank you. Put your hand down. How it works is you gotta wait till we stop speaking and then answer, because this is a record for you, not for me. So if you decide to appeal, the court reporter's gotta get everything, and it's just a terribly messy record when we interrupt each other. So we're gonna try not to do that, okay?
Yes, sir.
Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
Other than allergies, no.
I got allergies too. It's miserable this time of year, probably even worse in the jail. So are you taking, did you take anything for that? Or-
No.
But you're okay?
Yes.
All right, and counsel, you had an opportunity to speak with him?
Yes,
Do you believe he's oriented to date, time, place, and does understand what's going on?
yes,
All right, and he does seem that way to me too, despite allergies. And sir, you had enough time to talk with your attorney?
Yes, ma'am.
And you've been satisfied with her so far?
Yes, ma'am.
Very good. And sir, you pled guilty to count 1, controlled substance, possession of methamphetamine, punishable by 10 years. You were placed on probation, and I had to sign a bench warrant that was requested by probation agent Farr, and it alleges as follows. Count 1, defendant failed to report to probation following sentencing or any time thereafter, and his whereabouts are unknown. Count 2, defendant failed to comply with the Michigan Sex Offender Registry Act. And that would have been from a prior case. But still a requirement that you follow the law. And counsel, are you waiving further arraignment?
yes,
And as far as those are the only 2 counts.
That's correct, Your
All
Honor.
right, thank you. And will this be a plea or a hearing?
yes, Your Honor, it will be plea.
And sir, you understand the allegations?
Yes, ma'am.
And you're going to be pleading of your own free will?
Yes, sir.
No one forced, threatened, coerced, or promised you anything for your plea, is that correct?
That's right.
And you decided to plead after you spoke with your attorney?
Yes, ma'am.
And you were satisfied with the information you talked about with her and her recommendations and knowledge about the case?
Yes, ma'am.
Very good. As to count 1, failure to report to probation following sentencing or any time thereafter, and your whereabouts became unknown, and you were sentenced February 18th, 2026, so it would be failure to report after February 18th, 2026, and any time thereafter. How do you plead?
I give the honor.
And failure to comply with the Michigan Sex Offender Registry Act. How do you plead?
I give the honor.
Now, I should have asked, are there new charges on this or no?
Not that I could locate, Your Honor.
Okay,
Yes, and I would, and that's my understanding too, which is why we did the plea today.
okay, thank you. I'll tell you what, I don't know what the state's gonna do about this, so I would like to accept a no contest plea in regard to that.
Okay,
And, strike the guilty, because we don't know what they're going to do or how they feel about it. Maybe they'll look at what I do here and say that's fine, but just in case, let's have them do no contest.
I have no
Understand,
objection.
sir? No contest enters like a guilty plea, but it's you not admitting one way or the other, just because I don't know if they're going to bring new charges or not, so let's be safe. So how do you plead?
No contest.
Thank you. Sir, you understood that you were to follow the laws of this state and every other state, and you needed to show up for probation each and every time they wanted you to, and comply with orders of this court, correct?
Yes, ma'am.
And you failed to do that.
I did, Your Honor.
Were you sick, in a coma, jailed, hospitalized, or otherwise not able to comply with my orders?
Can I explain, Your Honor? When I left the court, when I got out of the jail, I made a bad decision and went to Detroit with a friend of mine. He's a judge at boxing, and he got arrested out there, and I got stuck in Detroit, and that's why I failed to report, because I was stuck in Detroit for like 3 weeks,
Okay,
and I couldn't get back. I didn't have no money. So I'm like, oh my God, I've already failed. I've already messed up my probation up. I haven't even reported. And
okay.
that made me scared right there. I'm still scared. The last thing I wanted to do is fail that. Because I never failed for probation. I always went to probation.
Sir, Detroit's not like Mars.
That's true.
Detroit has phones, and there are enough kind people in Detroit, including law enforcement, and most stores, restaurants, many people that are just walking around Detroit. If you said, can I use the phone to call probation, they'd let you call, and you didn't do that, did you?
No, I did not, Your Honor. And I apologize to the court.
I mean,
I
it's
didn't know it was under-
interesting to me that you can find drugs, but you can't find a phone.
Drugs are very easy to find, Your Honor. To be honest, they are very easy to find. They're everywhere.
So are phones.
That's
Phones
true,
and
Your Honor.
drugs.
But when you don't know a phone number, I mean, I don't have a phone. I don't know no phone numbers.
So.
I mean, I could have asked. Yes, I could, but I didn't take the steps to do so, and I apologize. I wish now that I would have. I wish I could just turn back time on it, but I mean, I can't do that, of course. But
See, sir, let me just stop you there. I would have a hard time, if I wanted to go find meth or heroin, cocaine, I'd have a hard time thinking, okay, how do I do that? I find that more difficult than saying, how do I find the phone number? A phone number, you call the operator, you hit the 0, and how old are you, sir? You're 58?
yes, sir.
Okay,
Yes, ma'am.
so you were around when there were no cell phones, and you just you had the regular rotary phone, and you hit 0, and you asked the operator? You could still do that on a cell phone. So I'm unclear how you find it easier to find illegal drugs and arrive in Detroit and all the things you do, but you cannot hit 0 and call us. You could also have turned yourself in to Detroit law enforcement. I have worked with them on many, many cases over the years. They would have called law enforcement here, given you a ride, we would have worked it out. You didn't do anything, did you?
No, Your Honor, I wish I could turn it back, but I can't turn it like what's already been done. I wish now that I could do it. I mean,
Yeah. Okay, well, I'm fine that you are in contempt of court. You failed to comply with orders of this court and the laws of the state of Michigan. Based on that and based on preponderance of the evidence, which is the standard, what's the recommendation of probation?
Yes, thank you, Your Honor. Mr. Keen has not completed probation in the past successfully. Parole was actually discharged on the maximum. I noticed that one of his terms of probation was revoked. So some of the things that he's saying is quite concerning. It's going to be very hard for us to supervise someone that doesn't have a phone, that doesn't have a residence, that is just frankly out and about doing whatever he pleases. He has been gone for 134 days. His guidelines are 10 to 23. As of today's date, since sentencing, he has 52 days jail credit. Clearly, he hasn't done anything on probation because he failed to appear after sentencing. He is not unfamiliar with the system, like you were saying, Your Honor. He knows exactly how to contact us, exactly how to reach out to us. But he has proven to this court and to the Michigan Sex Offender Registry Act that he is just not willing to comply. The last time that he willfully complied with the registry was in 2018, Your Honor. How other cases aren't out against him are beyond me. So it is recommended that probation be revoked. He be ordered to serve the 365 days that was held in abeyance of sentencing with credit for 52 days, Your Honor. Thank you.
Can you tell me, and you might not know this, and honestly, I don't recall because I do so many of these cases. I had ordered that he complete TRICAP. And I would have thought he would have gone from jail to TRICAP. Do we know why that didn't happen?
Your Honor, I show on the sentencing court note that he was to complete outpatient methamphetamine treatment.
Okay.
Again, I just inherited this case, but you know I researched them before I come to court.
Yeah, I know. And I honestly don't remember.
Yeah.
I TRICAP, I don't know that is outpatient. I don't know. Anyways, nonetheless, he didn't show up, so I was just curious because these orders were very specific to address his addiction and he didn't comply. So, all right, thank you.
You're
On behalf of the people?
Your Honor, I would agree with probation in this case. I am also looking at my notes from sentencing. I don't see that TRICAP was ordered in this case. I do see notes in my notes for the sentencing say NA, CA meetings and outpatient, but I did not see, I do see TRICAP in the original PSI, but I don't think TRICAP was ordered at the time of sentencing.
We'd have to look it up. I have the corrected PSIR and I did order TRICAP and I also ordered relapse prevention upon completion of the residential abuse, substance abuse program. So I was just curious, but nonetheless, I suspect he probably would have walked. There was nothing else complied with, so.
So I would agree with probation, Your Honor. Thank you.
All right, thank you. Counsel?
Thank you, Your Honor. We would like the court to consider giving Mr. Keen another chance. He has obviously struggles with housing, drug addiction. He doesn't have an ID and all of these things that in order to even to report for the Sex Offenders Registry Act, you have to have. So, I mean, those are obviously difficulties that prevent him from complying. And so I just ask this court to consider the violations as obviously not willful and consider continuing on probation.
Sir, what would you like me to know?
I just wanted to apologize to the court, Your Honor. I wish now that I could turn back things to where I would have went and that took care of my probation right away. I would have made the decision to go to Detroit, my friend. I would have took care of my things I needed to take care of. I just wish now that I would have done that. And I just want you to know that I apologize for that.
Sir, I suspect that when you're not high and you're not with the hoodlums that you're hanging out with, that you're just a very nice human being who has got some issues. And what you've done, because you do have this appearance of being just a good old human being, is you fast talked your way out of everything. And as a result, you have avoided the services that are so very needed. And I don't know if you have a death wish, but meth is nothing to fool around with. And you have a horrible record here. So, sir, you've been in front of courts, I've got 11 times, not the worst record I've seen, but you have assaulted crimes, you have intoxication, domestic violence, a number of those, prohibited drug purchase, felony, breaking and entering, unarmed robbery, and finally end up in front of me with the possession of meth and unlawful use of a motor vehicle. You have habitual offender fourth offense notice, sir. And I think that habitual fourth was dismissed at the time. Sir, you can't go on like this.
I understand that, Your Honor.
These now, because of habitual, It's life offenses. At some point, some judge is gonna put you in prison, and maybe I ought to do that. And you're gonna stay in prison, you won't get out on parole. So I think it's in your best interest that I keep you in jail and get you treated there. I don't know what else to do. You are homeless, can't find a phone, but you can't find drugs.
Is there,
What would you like me to know?
is there any chance I could get some kind of like a alternative sentence?
Oh, no, you failed this miserably, and the fact that you found drugs, you found a ride in Detroit, but not a phone to get a ride back. I mean, E.T. was able to find a phone. You couldn't. So 365 days jail, probation revoked, 52 days credit, no earned early release, no tether release, no trustee status. The jail will work with him to get an ID and birth certificate. That is a failure of our state. All indigent persons should have the ability to have a free ID and birth certificate. I've asked legislators to please fix this. They have not. It's also a failure of our federal government that they don't issue free social security numbers. And he does need a social security number, an ID, and a birth certificate in order to get treatment, in order to get housing, employment, and I think he's on SSI in order to reinstate that. So during the jail, we're going to advise the sheriff, because he does have a program that he started, because the sheriff and I might not agree on everything, but we certainly agree on this identification issue. He has a team and some grant monies, I believe, to help out with that. So we'll make a note that he should work with this defendant to get the identification. While you are incarcerated, you will participate in CATS program. You will participate in substance abuse treatment, AA, NACA, mental health treatment. Community mental health will come out and see you. And you'll also comply with sex offender treatment, because it appears that you haven't been registering. I don't know what's gone on with that, but your rights remain intact in regard to that. But we might as well treat everything I see in the record. And you should also, in regard to the mental health treatment, be afforded any medication if needed. And I think I said the domestic violence treatment, whatever else they find is related to him killing himself with illegal drugs and making him so angry where he's lashing out. So we're going to get you all the treatment that's available, sir. I hope that you comply, and I hope that you decide once and for all to be lawful and reach out for help. There are good people who will help you with the housing, employment, all the things you need. It's a lot easier to reach out for help than to go on the dark side with the friends you're hanging out with. You're gonna end up in a body bag, and if that's your wish, it will be granted. You choose what you want, life or death. There's no middle of the road for you anymore, sir. Good luck to you. You have 42 days to appeal and to request appellate counsel. Do you acknowledge your appellate rights?
Excuse me?
Do you acknowledge your appellate rights? Those appeal,
Yeah.
that document, okay. Sir, I hope that you decide to live a joyful life. You certainly deserve one, but it's up to you where you end up. That's all for the record.
It's second session live on a Wednesday. Ellie came up to join us. She's loving on everybody. You love your friends? Give your friends love. Good girl. Yes. If you're new to TCF, this is the official host is Ellie. I just am the human stand-in. Oh, thank you. Oh, that's good love. Thank you, sweetheart. Barbara, thank you for the $5 super chat. And Dog Mom, thank you for sending the treat jewel. I appreciate that. Let's go to the great state of North Dakota and check in with Judge Thornton.
Is adjourned. Next matter the court is going to take up, State of North Dakota versus Matthew Scott Huff, 02-2026 CR 75. Ms. Duffy appears on behalf of the state. Ms. Chisholm appears on behalf of the defendant. The defendant appears personally in the courtroom. Mr. Huff, were you present earlier when your rights were read to you?
Yes, Your Honor.
Do you understand your rights?
Yes, Your Honor.
Your case is scheduled for a jury trial on August 25, 2026. And after the court held its final dispositional conference on July 28, the court received information that you intended to change your plea. And so we scheduled today's hearing. Is that your intention, sir, is to change your plea today from not guilty to guilty?
Yes, Your Honor.
And will there be any charging amendments?
No, Your Honor. The state is asking, or I believe the parties jointly are asking for a restitution hearing to be held in relation to one of the counts. So if we can just do the change of plea today and the sentencing and restitution hearing together another day, that would be fine with me.
Ms. Chisholm, is that your thoughts?
It is, Your Honor.
All right. Sir, I'm going to share my screen so you'll have a copy of that charging document on the television. Give me just a moment here. You might have a copy of it in front of you with Ms. Chisholm as well, but nevertheless, you can see what I'm seeing. Sir, before we go any further, do you understand that you have the right to plead not guilty and have a jury trial later on this month?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving all the rights that were read to you before? And specifically, you're waiving the right to a trial of any kind to a judge or a jury. In this case, because it involves a felony, for 12 persons in a jury trial to unanimously find you guilty before you could be punished. You're waiving the presumption of innocence. You're waiving the requirement that the state prove you guilty beyond a reasonable doubt. You waive the right to confront and cross-examine witnesses against you. You waive the right to remain silent or testify for yourself. Present witnesses and evidence on your behalf and to use the court's subpoena power to force those witnesses to appear. You waive any and all non-jurisdictional defects in the case, if there are any. You waive all defenses that you could have had at trial, and you limit your ability to appeal the case if you enter unconditional guilty pleas. Do you understand all the rights that you're waiving by pleading guilty?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to plead guilty?
No, Your Honor.
Has anyone told you that you have to plead guilty?
No, Your Honor.
Are you freely, knowingly, and voluntarily and intelligently entering your guilty plea, sir?
That is correct.
You need any additional time to speak with Ms. Chisholm about your rights or about your case?
If we could get 5 minutes, I would appreciate that.
I do have another case that I'm going to call here in a minute, but it's going to be a lot longer than 5 minutes. You need just a brief moment or?
Just a brief moment.
All right, I'll give you that.
I was just wondering. I'm ready, Your Honor.
Mr. Huff, have you now had enough time to speak with Ms. Chisholm?
Yes, Your Honor.
All right, are you pleading guilty because there's a plea agreement in place?
No, not really, Your Honor.
Ms. Chisholm, is it an open plea? Is that what your understanding is?
That's my understanding, Your Honor.
So, Mr. Huff, just to confirm your understanding, sir, it sounds like there might have been some discussions and there's going to be a recommendation that the state makes. And there's going to be a recommendation that your attorney makes. And of course, before sentencing you, I'm going to give you an opportunity to speak. But I want you to understand that those recommendations are just that. They are recommendations. And from what your attorney is telling me, I'll be free to impose whatever sentence I think is appropriate or just, and that might be the maximum penalty. It might be the minimum mandatory penalty if there are any, or anything in between. It would be whatever I thought was appropriate. Of course, I'd listen to both sides' arguments, but I'd be free to impose a sentence that might be different than what you expect. You understand that, sir?
I do understand, Your Honor.
And do you still want to plead guilty knowing that there's no binding plea agreement in place?
Yes, Your Honor.
It's been quite some time since we've had the arraignment. At that arraignment, I explained to you your rights, what you're charged with, the maximum and minimum possible penalties, court fees, restitution, immigration consequences, and the potential for other adverse consequences. Do you recall that conversation, sir?
Yes, Your Honor.
Do we need to revisit that conversation, or do you remember it good enough that you're comfortable moving forward?
I'm comfortable moving forward, Your Honor.
All right, sir. So if you look at the screen, in count one, you're charged with unlawful possession of drug paraphernalia, a Class C felony. The state alleges that you possessed paraphernalia used for ingestion of a Schedule 1, 2, or 3 controlled substance other than marijuana, namely a smoking device and syringe used to ingest methamphetamine, and you have a prior counsel conviction in a 2023 case. To that charge, how do you plead, guilty or not guilty?
Guilty, Your Honor.
Count two, the state alleges that on or about that date, April 6, 2026, in Barnes County, that you committed the Class C felony offense tampering with physical evidence by believing a criminal proceeding was about to be instituted for felony drug paraphernalia possession. You altered, destroyed, or concealed an item of paraphernalia with the intent to impair its availability for an official proceeding. It's a Class C felony. To that charge, how do you plead?
Guilty.
Count three, on or about April 6, 2026, the state alleges in Barnes County that you committed the Class B misdemeanor level offense, criminal mischief, by willfully damaging a garbage can belonging to Naomi Koch. That's a B misdemeanor. To that charge, how do you plead?
Guilty.
And count four, the state alleges on or about that same date in Barnes County, you committed the offense of Class B misdemeanor criminal mischief by willfully damaging the rain gutters of another. To that charge, how do you plead? Guilty or not guilty?
Guilty.
All right. Ms. Duffy, a brief factual basis, if you would, please.
Back on April 6th of 2026, law enforcement was dispatched to an area in Valley City. They received a report that there was an individual who was climbing on top of a trash can and then climbing on top of a roof garage of some condos. Upon arrival, law enforcement came into contact with the defendant, who was identified by the person who had called law enforcement. In their investigation, they determined that the defendant had climbed onto the garbage can and then on top of the roof. While doing so, he caused some damage to the garbage can. He also caused some damage to the gutters of the roof. When he was being detained, he had a pink kind of carrying case with him. They had asked him to set that on the ground, so he did. The defendant then had kicked that pink carrying case into a storm drain while he was standing there with law enforcement. They subsequently conducted a search and found a smoking device and some syringes that, based on their training and experience, they believe were used to inject methamphetamine into the body. The defendant does have a prior counsel conviction as outlined in the criminal information. All of that occurring here in Valley City within Barnes County.
And Ms. Duffy, I want to make sure I understand your factual basis. The search was of Mr. Huff's person or of the pink carrying case kicked into the gutter or the storm drain?
So the pink case, well, both. Upon searching his pockets, they had located a syringe with a trace amount of liquid that they believed had methamphetamine within it. So there was drug paraphernalia on his person. Within the pink case, there was some marijuana stuff in there that wasn't charged out, and 3 additional glass smoking devices.
And so the tampering with physical evidence was some item of paraphernalia that was inside the carrying case kicked into the storm sewer?
Yes, Your Honor.
All right. Thank you. Mr. Huff, is that what happened?
Yes, Your Honor.
Are there any other additional facts that you would like me to know?
No, Your Honor.
Ms. Chisholm, do you agree a sufficient factual basis exists?
I do.
All right. So the court is going to accept the guilty pleas to the counts as alleged. I'll find the same freely, knowingly, and voluntarily and intelligently entered. The court will find an adequate factual basis to support each of the defendant's pleas. We will continue sentencing until a later date. At the same time, we will hold a restitution hearing. Right now, my court recorder, Ms. Strom, is not in the courtroom. I have another recorder who is recording the proceedings, and so I don't have a date for you right now, Mr. Huff. But I will get that date and provide it to your counsel in writing, so stay in touch with Ms. Chisholm. How long do the parties think they need before we have sentencing to address the restitution issue? Is 30 days enough, or do you need 60?
30 is enough.
30 is enough?
Mhm.
Ms. Chisholm, do you agree?
That would be fine, Your Honor.
All right, so roughly in about a month, we'll hold our sentencing, and I'll get you that date in writing. Both counsel will receive notice of that hearing in the ordinary course of the court's business, but I don't have Ms. Strom sitting next to me to give me that date. So expect it will be in approximately 30 days. Anything else, Ms. Duffy? Ms. Chisholm?
No, Your Honor.
All right, this matter is adjourned. Stay in touch with your counsel. All right,
Thank you, Your Honor.
have a good day.
Alrighty, friends, it is second session on a Wednesday? Yeah, it is Wednesday. I lose track. I'm like always live all the time now. It's hard to keep track of what's going on. The next thing I've got for you is a Judge Oakley preliminary examination, and it will close out the show and be about half of the show. It's a little over a half an hour for this hearing. But this is a preliminary exam, and let's just say it's on a 4th degree assault. That's the best way to phrase it and be relatively YouTube friendly. I don't know why I'm bothering, because as soon as I play this, we'll probably just throw that out the window anyways. But all that having been said, Judge Oakley.
All right, 34th District Court now in session, Honorable Judge Oakley presiding.
Have a seat. All right, gentlemen, your appearances for Jonathan Monroe.
Good. Afternoon, Your Honor. Please let me hearing of the people, PA 400.
Good afternoon to your honor, Madam Clerk. Obviously, speak for to be made on behalf of Mr. Monroe, who stands to my left. Please take it forward.
Good morning, Your Honor, Jonathan Monroe.
Thank you, gentlemen. Are we ready?
Your Honor, you're prepared to proceed, however, I noticed there was an issue with the felony information or the information on agreement here. Or as received, there was a missing habitual third offender notice, which the people has needed to.
That's fine, numbers.
However, I think yeah, I mean, it wouldn't really matter if those sentencing regardless. I guess it's just board will put in defendant on notice today on the record that we can do.
Understood, counsel? Okay,
We'll amend the information that it comes to serve.
okay,
But yes, the people are ready to proceed. Stand your own.
okay. Let's call a witness.
The people first call Jessica Osborne to the stand.
Ms. Osborne, all the way up front. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth today? Watch your step on this incline ramp. Settle in that chair right there. When you're ready, Mr. Leckie.
Good afternoon, Ms. Osborne. Can I please state and spell your name for the record?
My name is Jessica Osborne. It's JESSICA, Osborne, OSBORNE.
Very good. But I'm gonna, just because I can navigate everything. So you guys have phone just move it closer. It works. Okay. All right. So, Ms. Osborne, were you, do you know anyone by the name of Jonathan? Okay, and who is that person?
He is my ex-boyfriend.
And ex-boyfriend, so it's fair to say that you would be able to recognize him if you see it again?
Yes,
Okay, and is he in the court protection?
yes,
Okay, can you please take a moment and point to him and identify him by what he's looking at?
right there. I don't know if I should.
Okay, Your Honor, at this time, I'm going to ask the record reflect witness to identify the defendant.
Noted.
Okay, now, were you with that individual on July 10th, 2026?
Yes, I was,
Okay, and where were you?
I was in Promise, being the show. By the, resort,
By what place?
the resort.
A hardware store. Okay. And what happened?
He was drinking and he was going for being hostile, laughing and crying. He was punching my car.
Okay, so let's back this up. So what time of day was it?
When the incident occurred, his name was about, we started around 8-ish.
Okay, is that in the evening or the morning?
He,
Okay, and now you said he was drinking, so where are you? So you're at a party store, where? Okay, parked, meaning you're in a car?
Yes.
Who's driving? Okay, and you said he was drinking, was he drinking in a car?
he were outside and he went in and got
Got blown.
I
Okay. So, bottle of what, do you know?
it was
And what is that? Okay. So, what kind of offering? And what did you see him do with it?
he was drinking.
Okay, the whole thing?
He was, yeah.
Okay. And at some point in time, does he come back?
He was in my party. He said he was talking to me honest. Yeah.
And I'm sorry, so you gave him 30?
He said, we were talking, pretty much about show. And
So I want to stop you there. So did you arrive with him?
no,
Okay, so he was there and you arrived separately.
I arrived at the store first. He was speaking, I suppose.
Okay, so you met,
Yes,
and he asked you to speak for 30 minutes before he will write, what is that?
that. He wasn't letting me leave, he wanted to get out of me.
Okay,
I got to tell him I had those, and yes.
okay, because you're kids?
Yes,
Okay, so what happened?
and he talking about us, and it was just, it was all back and forth, talking about us and everything was all around. Sound.
And what does
Start
that,
singing.
what was that?
Sound.
Yeah, so he said you've been talking about us and most people.
Yeah, he's talking about because. Because
Okay, are they your kids or?
it's better.
Okay. And that's right at the beginning of this 30 minutes?
We're listening to music,
Okay,
and then songs play. He sang, cried, laughed, and started punching. I dashed in the window,
so he punches your dash in your window from the inside or the outside?
and it's like,
Okay, and what did that do?
it broke my window.
And. Okay, moving on from that, what else?
She's a song story. Because I was driving a lot of people. And so you get in for he automatically, you know, front of 99. You know, they're just looking at me. The last time I went to the store, they actually at me.
And that's the sure,
Yes,
or whoever was.
the floor.
So, I want to get back to the car. So is there any time you said he's punching the dash and then the window, is he punching you with?
No, he did. He said, "Well, that but he photographed it."
Okay, so for the record, I see you moving your right hand, open palm, in the direction right, so left outside your body to or inside your body. almost like a slap, right?
Yes.
And then in fact, you made a slap sound with your hand, is that what you said? Okay. So, and you said he kissed you, is that right?
Yeah,
Okay.
he had a little over.
Grab your kiss, did you ask him something?
Yes,
Okay, did you do anything else?
he just grabbed my thigh.
Okay. Where,
I think so much.
okay, and
But he did not touch me.
what do you mean by that?
My heart.
Did not touch you in your right, okay. Did he touch you anywhere else?
No, he's always grabbing me because of me.
Now, your inner thigh, you said how close to your privates?
About 2 inches.
Okay. Now. Okay, when he was kissing you and touching your thigh, did you guys do something?
Yes.
Okay, wow.
Because of the whole movie. Very upset.
And what do you think was happening?
I'm scared. I'm everything I want to dash my phone.
Now, did he touch you anywhere else? Now, when he was kissing you. Sorry, that for you.
After fire. See my fire was tired. I was sort of like tired. I was sort of like, he was like the little back.
Okay.
He was right on my face, on me.
Okay, now, at any point. How intensely was he kissing? Was it just a little pass, or can you, how would he kiss?
I don't know what.
I'm sorry?
I don't know what to play for me.
Okay. Was he? Now, are you sure that he didn't touch your privates?
Objection, Judge. It's been asked today, it's available, and it's a closing today. Are you sure?
Any response?
Sir.
Asked and answered, move on.
Now, is it that, do you remember any other times?
I was all her daughter. She was at home. She had to fence. He's closing home to leave.
And I just mean physical. So when he's kissing you, I kind of asked, was it a peck or anything like that? And you didn't really answer that. So how did you start on this?
I was gonna say it's my face kissing me. My face kissing me. Bad.
Did it go beyond this? Okay. His tongue didn't finish your mouth though. So your mouth was shut. Like he didn't force anything in your mouth. Okay. And you filed. Now, at some point, did you call the police?
Yes, I tried to use that last time. So even every other day.
Okay.
From that, I did the SOS. I was trying to get people involved. At the same time, as I get stored, I did the SOS for people started trying to follow.
And who's
And I put it in my bag, all that.
Okay, I'm having a real hard time understanding this woman. So start over with SOS. Did you say he snatched your phone?
He wanted to try to snatch my phone, God.
Okay.
I don't have the SOS.
okay, so
On my phone, you can ask it to call, or you can just slide over and calls. Emergency services.
okay.
So I did that, I did part of my bag wasted. Because of
But at some point, you go to the police or
yes,
okay. And do you make a statement still?
yes, the,
And you sign it, right?
yes, the,
And in that statement, did you tell them exactly what?
yes, the.
So then I want to approach Okay. And then, I'm sorry. The last thing I asked you was actually exactly what happened, correct?
Yes.
So I want to approach your statement.
Yes.
Yeah, and I want you to read it. I see some questions about me. Okay, so don't read it, talk about it. Just look at it first, and then we'll talk about it. So you can go ahead and grab it. It's 2 pages. Okay. And then flip it over when you're done. Okay. Is there anything different in that statement than what you're testifying to today?
Well, Judge, I think that's proper. It's not a refresh that you can teach you. So, what? This is a way to correct witness testimony.
So what's the legal objection so I can have Mr. Leckie respond?
You're saying what's the proper refresh, in which case of all speakers.
Counsel.
I think that's it.
Try that.
Now, you just stated that everything in that report is accurate, where, correct?
Yes.
Okay. Now, I want to ask you, was there anything that you left out today that's at all?
I don't understand what you're saying. You've got to speak more clearly and speak up. I don't want a translator. I want to hear her say what she's trying to say.
Take a second.
That helps having the mic close to you like that.
You want
You need something to drink?
everything? What is the starting with that? Sort of around certain parties where he was getting ready punching at her. Had her on the face against me. He was kind of one from.
So, I'm just saying that one. So did you tell Officer there that touched your body?
Said he was having your eyes.
Well, did you write in that statement that he touched your body?
He was going to
So I understand, but my question is, in that statement that you just read, did you write in there that you touched your body?
Yes.
Okay. So is that what happened?
Yes.
So you did touch your body?
He very between my thighs, about the right there.
Okay.
Where he was grabbing my thigh. Yes. Gosh.
Right. It touched your body?
Yes.
Okay. That's it, thank you. I'm gonna go grab that from you. There. Okay, and I am looking for this. That's thank you.
Yeah.
Good afternoon, Ms. Osborne. I just have some questions for you. If you ever need me to rephrase it, you just let me know, okay?
Yes.
So, Ms. Osborne, I want to start first with that statement you reviewed. To be clear, do you remember writing out this statement when police asked you?
Yes, she.
And did police give you an opportunity to kind of collect your thoughts and write down what happened?
Yeah, the circumstances of what's going on.
Understood. And in that statement, you wanted to be accurate, is that what you said?
Yes.
and just try to remember as much as you could about what happened given the circumstances.
Yes, sir.
You'd agree with me, Ms. Osborne, that there's a part in that statement where we're able to indicate and almost like circle what happened to you, correct?
Yes.
You agree with me that in the places you could circle, you could mark whether or not someone had inappropriately touched you sexually, correct?
Yes.
You could mark if you ever were touched, sustaining injuries, correct?
Yes.
You could mark whether someone restricted your freedom of movement, correct?
Yes, sir.
We're reviewing it again fresh. You're reviewing it to see where you're looking.
Why the river?
We're reviewing it to self.
I don't know. Why, sir?
So that's what I'm saying. We're reviewing it to see what your circle felt professional.
I do, but my sort is going to be the same.
Understood.
So,
May I have questions?
Sure.
Is that very fresh? Okay. You'd agree with me, Ms. Osborne, that you did not circle that there was any bodily injury, correct? Did you circle it or? Okay. Did you circle where it said sexual assault? Did you circle where it said interference with freedom of movement?
I believe I did. I didn't know some glasses. Somewhere.
I think circling where it says other, were you describing it? Okay. And how soon was this taken after the incident?
I entered that for over 4 hours, so I'm mad, but thank you. And we have to have it on those guys.
And I want to talk about when you're saying that Mr. Monroe goes to the store. Is he going to the store by himself or are you going to?
No, I had you want to go by something. I think about it.
So each time you're saying you're going in and out of the store together.
Yeah,
And you said that you arrived at the store first. So I want to clarify why you were at the store. To be clear, you don't live in that store, do you?
no, he was very close.
So I'll just break that down a bit. You live in the park, correct?
Yes,
Outside of Mr. Monroe being there, you had no reason to be at that place, so correct?
I actually go there every day, go around, whatever, get it straight, and I even have you have to.
You're saying you live half a mile from
I don't see those guys actually work. Right on the street.
at the top of it?
No, first.
Okay.
The airport.
So you're saying you live right down the street from the park?
She says she works there constantly.
Right on the street.
So you work right down the street from the park, so you say you, prior to this incident, go every day?
No, work on break.
The question was, at the time of this incident, you were at that store on a regular basis.
Yeah, gentleman called me, he wanted to talk.
Okay, so there's testimony that he asked you to go to the party store?
Well, that's not in there, but.
That mess,
Yeah,
it's not the
no, he
same.
said, I have messages,
Okay. Messages and voicemails from his number?
yes,
Okay. And to be clear, he would have been texting or calling your number?
yes,
Okay, and that's the number ending 0083, correct?
yes, sir.
Now, you told the police, Miss Osborne, that you asked to meet Mr. Monroe, is that correct?
No, I did not.
Well, specifically, you told police that you asked
Where
him
is
to
it?
come over to talk about your children.
That's not what I said. At all.
And to be clear, you have 3 children.
Yes.
And you had mentioned that part of this was about your older son.
No. That's not what I said. We were talking about credits, and asking because to be honest, because he missed his kids.
You're saying he missed his kids. These aren't kids that have to come.
You know, it's all.
So I just wanted to make sure the record's clear. Solid. When I'm asking a question, you can wait. I already know the answer, but we just need to make sure the record's clear. Okay. Got it. Thank you. So I'll just ask again. You all do not share your children, do you? And when you were at the party store, did you drink at all?
I had no shot because he got put it in my face.
Did you drive at all?
No, I was just in a parking lot for 5 hours being held.
Good.
Yeah. Oh, yeah.
You never left to go to the park.
Oh, yeah. I was not drinking. This is waiting for that. This is waiting for that.
Okay, so you actually saw him earlier.
Hours before that.
And then you decided to meet at the park.
We were at the first store. That's it. Our legal name on the legal consent. We busted around the hour.
There's no question on the floor.
So, Ms. Osborne, is it true that earlier in the day you texted Mr. Monroe to meet up to have sex?
No, not at all.
You did not?
No. I have
At the time.
I have messages.
Did you show us the police?
No, I didn't have my phone.
In terms of this relationship, were you all still dating or were you exes?
We're exes. He got back, we come back home, things are long.
Now, how long did you settle?
Right. Because I think longer than he was busted.
That doesn't help us because I don't know when the funeral was.
Said,
Yes.
and you're saying that he no longer lives with you at the Lincoln Park?
No.
Okay, did he ever live there?
Yeah.
And then after March, he no lived there?
No.
You said that you were trying to, and I want to go back now to what, right, so you said you were trying to get people to call. So you're saying that there were folks around that party school who observed this happening.
Yeah, I think he was.
Okay, so customers,
He was saying you better call for every time they execute me. That's what he was saying. He was very hostile.
okay, so to answer my question, I'm talking about people around.
Yeah.
Were there customers in the store?
Yeah.
Okay. And you're saying they observed what was going on?
Yeah.
There was a store clerk or the store owner, correct?
Inside the store. There were no customers inside the store.
But you said that you would enter the store as
Yeah.
parts. Did that store clerk or store owner make any observations at that point?
No, they're not objective. No, like, what, I don't think she can testify with the store.
It's her.
Miss Osborne, you keep talking when other people are talking. I'm done doing that. Your response?
To my objection, I'm sorry.
Yeah. You were in the middle of your objection when Miss Osborne decided to add something.
Again, I'm objecting to her ability to testify to what the store owner observed.
I didn't think.
Rephrase.
So, Ms. Osborne, did any of these interactions you had in the store take place in front of the clerk or the owner?
We love the story, Gravity. Oh. They speak their lives, I cannot say what they.
Okay. And did you ask anyone in the story call, the police or no? Okay. And you said, oh, to the customer, to both the clerk.
Both.
Okay. And then you're saying there are multiple times actually we're going in slow fair. So at multiple times we asking people to help you either outside the store, inside the store.
I was going to the store to deal with, I mean, excuse to a chef store. So where I could eat and grab my phone to last was emergency. And I learned my bag with back with Sam. You know, and that's the store and then well the store was smaller, we're all in that here. Do my phone. Then I have to call back. Talk to this, but
And you were talking to police while Mr. Monroe was in the car.
we were inside, we were walking out of the store. So I had sat with my kids, we tried to section the phone.
Okay, so you had that conversation with police while Mr. Monroe was next to you.
He not next to me. I was actually back away from him. And he had a short time t-shirt. And they all pulled on.
Okay, so I think you need to answer my questions on the solid one. Was Mr. Monroe next to you when you spoke to the police or no?
He was about a little bit. Probably the years into me.
Would you say that's about 9 or 10 feet?
I guess.
Now, when police arrived, did you have any injuries on them? Did you have any blood? Did police offer you medical attention? Is it true that you given false reports to the police people?
No.
It's not.
No.
Is it true that you've been arrested for assaulting and stabbing your partners?
No.
Did you provide any receipts of the repair to your people?
I don't know. Where's
Where is that?
Sneeze. Otherwise.
Okay. Thanks. Nothing.
Mr. Oakley?
So I have a couple of questions just to follow up.
Okay.
When he was touching her in the car, what did he say? When he was touching her in the car?
He asked to have sex. I don't know. I wasn't married.
Okay. And then the last. And how did he respond to that?
He asked to face it. Started kissing.
So,
He started punching my dashboard. Then everyone told him.
and then I went to. as what you said, someone said, you know, if they come better percent, whatever. Okay, what's that?
He was talking about the police.
Okay,
And then he even jumped out the car and fight customers was trying to.
you're on motion.
Ms. Roberts, any recross? Ms. Osborne, you step down. Watch your step on the ramp. What's next, Mr. Lucky? No defense, risk. I'm ready for argument.
To reserve for rebuttal, but for a probable cause standard, all we have to prove is the criminal sexual conduct in the fourth degree, which requires me that I prove that there was sexual contact, that being the touching, state of the thigh and private area, as this victim stated, and it has to be, sorry, and that it has to be for a sexual purpose. She testified that he asked for sex, she said no, in which case it looks in the mind for what it leads me to believe could be inferred as a sexual purpose.
Sure, understanding that people don't need to provide evidence for the misdemeanors, all just speak to count one, which is CSC 4. At first blush, Judge, this complainant said that it was not for a private area. I think there was an attempt at an impeachment to get her to conform to perhaps previous statements. In any event, I mean, the first thing that she stuck with was he was inches away from the private area. At that time, we heard nothing about this being him asking her to have sex. That was something that was no redirect. And actually, the reason there was no need for me to recross on redirect is because the timeline that Mr. Leckie laid out for redirect explains why this cannot be a CSC 4, even if you were to believe what she said. Because as Mr. Leckie asked, what happened after your private area was touched? At which point she's alleging that Mr. Monroe says, let's have sex. She says, no, I'm on my period. At no point does she say, then Mr. Monroe continued against my will to touch my private area or force me into a position, because again, CSC 4 requires force or coercion. The law does not punish, and I don't believe what she's saying, but even if you took it in the light most favorable, the law does not punish people for trying to initiate without force or coercion sexual contact. It does penalize if, when it's no longer consented to, you use force or coercion to overcome the lack of consent. She's saying that he was punching the dash, doing this, doing this, doing this. She never says that he continued to touch her private area or near the private area. So there's not sufficient force, even if you believe everything that this witness said, which I wouldn't. Even if you did, the timeline illustrates why this cannot be a CSC 4. I think the credibility also, Judge, was put on full display as to why the story doesn't make sense to me, at least, how she's at this store often, but not really, and then she's there to meet about kids and give clothes back, but they haven't been together since March, so why would she have his clothes? You know, but again, taking it like it's favorable is not CSC 4 because there's no force or coercion for the sexual contact itself.
Mr. Leckie.
Specific with language before I use it.
Sure.
Okay. Your Honor, and this is I go on there a second. Read closer to the record. Okay. So Your Honor, the criminal jury instruction for criminal sexual conduct in the fourth degree is a little more inclusive than at first I was anticipating. However, a touching of the inner thigh also consults to a results in a criminal sexual conduct in the fourth degree. So even without that general contact, which I don't think it was a force of her or a lack of her trying to, press something. I think it was sheer nervousness. You heard it in the way she was shaking. Her tone was very low. She was nervous, and she stated on the record that she was nervous to talk about the touching of her private, which I think is understandable. However, that is an issue of credibility, which I think would go to a jury. So, Your Honor, we're left with a CSC fourth degree that has to prove force coercion. She stated, I don't want to don't kiss me, had her lips closed, was fighting off his advances throughout this entire. Now, the reason why I bring up the reason why it's important as stated, and I don't think the timeline necessarily matters, just because he said it after he touched her thigh doesn't mean that he didn't have, the requisite mental intent to have sex with her in the moment he stated that word. I mean, he was touching on her thigh. It can be reasonably inferred that that was for a sexual purpose or for sexual gratification, which is what the statute requires. You need a purpose for a sexual purpose or sexual gratification. Now, he is touching on her thigh. He touches her private area. Even if the court doesn't believe that testimony, the inner thigh is a touch. He was kissing on her, attempting to get some sort of sexual gratification from this woman, and she refuses, and he still overpowers her. Touches on her, he is hitting her. There's a lot of stuff that goes on. Breaking her car, that, Your Honor, I think there's enough for probable cause to assume that CSC 4 had.
Mr. Roberts, any response?
I think the response by the people leaves out the force or coercive part. Even if, again, we're taking like most favorable to the people, that there was a sexual touching, that sexual contact must have been accomplished through force or coercion, meaning it's not enough to say that I was touched on my inner thigh and I didn't like it, or I was touched on my butt and I didn't like it, or I was touched on my genitals and I didn't like it. That would be an assault and battery. What makes it criminal sexual conduct is that the sexual contact was accomplished through a separate element, which is force or coercion. Kissing someone, right, inappropriately, if you agree with her, would be assault and battery, right? The alleged slap would be assault and battery. And mind you, these things are happening after the sexual contact had already allegedly happened, right? She's saying that he got angry because she refused sexual contact. Okay, but that clearly shows that the sexual contact ceased and he was doing other things, allegedly. So if those things don't lead to another act of sexual contact, then you can't say that, even based on her testimony, that she's describing an incident where someone is attempting to make sexual contact through coercion or force. It becomes an assault and battery, which I think is plainly more in line with what she originally testified to anyway, until we got the kind of improper impeachment, in my opinion, that she was touched on the thigh. She's saying she doesn't want it, which of course any person can say that. I'm not saying that, she's said that it was consensual. We can agree, based on what she said, we want it to be consensual. But where's the force? Where is the force to accomplish sexual contact? That is not present, therefore, at best, this is an assault and battery. I think that's even what case law said. If every touching was a criminal sexual conduct, then the legislature would say so, right? Something to that effect. We don't make all butt touchings sex offenses in the state of Michigan. We don't make all thigh touchings in the state of Michigan criminal sex.
Mr. Leckie, help me understand your argument. What is the force that you think is the fourth degree force or coercion? What force in this fact scenario?
I think necessity is coming from the fact that her face was grabbed and a kiss is being forced on her, then after which, or during which, he's grabbing on her thigh, or touching her genital area. She's saying, stop, I don't want that. And then after he asks for sex, maybe. I don't think the timeline was fairly clear, and that could be on my part, and I'm happy to recall her if that's what the court would like. And reopen the proofs if that would clarify that issue, because I think that may have been a possible error of mine, but it's my understanding when I asked her what was going on, there was kissing, he grabbed her face, she had her lips closed.
She made it clear that she didn't want to be kissed.
And then that was followed by, because I asked what happened, did Reeve also touch anywhere else? Then she included that touching and that feeling of the inner thigh. So, Your Honor, I think that is the necessary force. I mean, the kissing is not one incident. We're not robots, we're humans. We don't, as soon as we're done kissing, we don't reset. Let me do another action. Oh, that has a different intent. Let me do another action that has a different intent. That's not what we're doing here. This is the continuous flowing series of events that I think all plays into this defendant's sexual desire, his state of mind, and all go into what he wanted and kind of the emotions that were running at the state of mind. So I think there's enough for like.
All right, thank you. I'll give you one more shot, Mr. Roberts. Anything else?
Also, what I said, I think the witness made it very clear to the final events in redirect. And I, the touching is happening allegedly, and then it's followed by what she's claiming to be retaliation for the touch. Then the retaliation and forcible coercion is happening after the sexual contact. And if that's the case, there is no force or coercion that would satisfy the CC quote.
Okay. I'm going to bind over. I'm looking at the totality. I think 3 different times in her direct testimony, she mentioned that she was there for 4 or 5 hours. He wouldn't let her leave. She said she kept going in the store to get away from him. He wouldn't let her go in the store alone. He was forcing his affections on her to the point where she was as far away from him in the car as she could get. I'm not really clear on the timeline when the various things happened, because I think she was all over the board with that. But it was obvious that there were many. His affections were not wanted. She was trying to get away from him. At some point, he touched her on the inner thigh and said, "Let's have sex." I agree with Mr. Leckie. His what he said and what he did made it pretty clear that he was interested in sexual gratification. I'm going to bind over on the felony. AOI is the 25th at 9 a.m. Anything as to bond, fellas?
Thank you.
Bond will be continued. Mr. Monroe, good luck downtown. Mr. Monroe, you owe us $800 or $340 that you've owed us since 2021 on a parking ticket.
So bound over, and he's going to be sent to the cashier to pay his parking ticket. All right. Well, there you go. That's it for today, friends. We will be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. And tomorrow is Thursday, so we will have second session once again, 2:30 p.m. Eastern, 11:30 a.m. Pacific time. Go have yourselves a good day. We'll see you soon. Take care. God bless.